Good morning, rather good afternoon. Thank you for taking an interest in our subject. We're happy to welcome you to this roundtable, which is to be dedicated to issues which have to do with both Russian companies operating internationally and foreign companies which have their divisions in Russia. And the subject of our roundtable is the employee in a transnational company, the hiring of foreign personnel in the context of globalization. And I am happy to introduce to you our speakers who will try to cover the most important issues we're going to discuss, not only in terms of from the perspective of the Russian law, but also from the perspective of other countries, because we're having here representatives of international organizations who deal with employment law. I'm happy to introduce to you Karin Varga, International Labor Organization, where he has worked since 1988 and advised on national labor law reform as part of poverty elimination, private sector development, and economic restructuring programs. She is head of the Fundamental Rights and Principles at Work Division. Mr. Roberto Suarez Santos is a representative of the International Employers Organization of Employers. He is Deputy Secretary General of the International Organization of Employers. He is a professional lawyer with considerable experience in international labor law. He has been doing research, a member of the European Social Dialogue, and president of the Corporate Social Responsibility Group in the European NGO Business Europe. I'm happy to introduce to you Ekaterina Yegorova from the Federal Migration Service of the Russian Federation. Ekaterina Yegorova is a full state advisor of Class 2 and first vice chairman of the Federal Migration Service. Mr. Denis Danilov, who is of Gazprom Neft, who is both an economist and a lawyer and has been in the oil and gas sector since 2004. He is head of the Legal Support Department for Operations. He will share his experiences in employment practices at Gazprom Neft. And we have foreign lawyers specializing in labor law, Sophie Myers, Kleisen Engels, a law firm, a specialized boutique firm, Belgium. Sophie deals with mobile employees and is co-chairperson of the Global Mobility Group as part of the Laboris International Alliance. Now, Yulia Borozna of Pepelyaev Group. She has vast experience in labor issues. We are happy to congratulate you on being elected chairperson of the subcommittee of the European Labor Law Business Association. Mike Siberia of Italy, an Italian company specializing in labor law. Stephen Fisher, Clinton Falstadt, Germany, a firm also specializing in labor law, and Stefan is at the head of the mobile employee mobile staff group at Jus Laboris. We would like to begin our discussion today with socially important issues, and I would like to give the floor to Karine Varga as of the International Labor Organization. We know, Karine, that you have recently visited a conference, an important conference where a certain protocol was adopted. And could you brief us on the issues currently in the focus of the International Labor Organization?
Everyone. As Irina mentioned, I'm working for the International Labor Organization, which is the organization within the United Nations agencies that are dealing with labor and employment matters. And as you rightly said, we just finished our International Labor Conference, which is held annually in Geneva, where all the member states are joining for 2 weeks discussion. And member states within the International Labour Organizations are represented by governments, mainly ministers of labor, but also employers' organizations and trade unions. And this year, indeed, it was one of the items on the agenda of the conference was, as you mentioned, the adoption of an international treaty, which is the protocol that's supplementing Convention 29 on forced labor. But before explaining to you what we've been doing in the conference, let me perhaps put our discussion into some perspective and global perspective. And this will also provide for the discussion of this panel some global perspective. So first, if we go into the context, and I think there are slides that are going to be moving up on the screen for you. Let me share with you, I'm going to use this nice device. So let me start by putting to you a number of critical figures that are explaining the global context in which migration for work and hiring of employees across borders is happening. The latest estimates on migration estimated that there are currently 231 million migrant people, so people that have migrated out of their countries. And most of these people have migrated out of their countries for work-related purpose. Another important phenomenon and worrying phenomenon that the ILO has been observing and monitoring very closely recently is the phenomenon that's affecting nearly 21 million people worldwide that are trapped into forced labor. And by forced labor, we meaning people that are delivering work or services for which they have not volunteered themselves, and they are trapped into, and they are delivering this work and services under the menace of sanctions or penalties. So we have 21 million of people doing work involuntarily under menace of sanction and penalty worldwide. While this phenomenon has started and has been observed a long time ago, at that time, it was mainly the state that were forcing people to deliver work and services. That was 80 years ago when the first International Labour Convention, which is the International Labour Law Framework, adopted its first convention on forced labor. Since then, what we're observing is a drastic change in the phenomenon And forced labor has moved out of the public economy to the private sector. And currently, 80% of forced labor is being practiced in the private economy. There is no single region in the world that's not been affected by this problem, by these challenges. While we're observing a vast majority of forced labor in Asia, the high prevalence of forced labor is taking place in Europe, and mainly in Central and in Eastern Europe. So all regions in the world are faced with this growing phenomenon of forced labor. So what's the link between migration and migrating for work and forced labor? It's because actually we are observing that 44% of forced labor is linked to migration and is affecting migrant workers. So here we're talking about 9 million of people that have migrated for work and end up doing forced labor in their destination country. The sectors in which this is happening range from agriculture, fishing, but also affects manufacturing, utilities, services, domestic work, just to mention the most critical sectors in which we are observing this phenomenon, including in Europe. So if I'm moving to the next slide, people that have migrated out of their country and end up in forced labor have often been using the services of placement agencies. So placement agencies are a critical actor in this migration for work phenomenon. And the latest estimates we had had identified 140 private recruitment agencies operating worldwide. And the reason why we're highlighting the role, this critical role of private employment agencies and private recruitment agencies, it's because we are observing that they are often at the center of the problems and of the abuses. Not all of them are, but some are really key causes of this phenomenon of forced labor. And the reason why they do play a critical role and are often leading into abusive practices, it's because migrant workers have to pay huge recruitment fees to these agencies, including transportation fees, which, depending on which workers are using their services, may force them actually to borrow money and to get into debt bondage because of these huge recruitment fees. In 2009, we have estimated that 1.4 billion US dollars was lost to illegal recruitment fees by workers, and those workers also have lost $19.6 billion in terms of low wages or underpayment of their wages. An extremely recent report produced by the ILO has come up with even a most worrying figure that the illegal profits generated by this forced labor, out of which, as I said, 44% relate to migrant workers, have generated 150 billion US dollars benefits per year. So if you just thinking of 21 million people in forced labor generating 150 billion illegal profits, it's bigger than the GDP and the population of many countries in Europe. So we're talking here really an important phenomenon. The abuses that migrant workers occasionally face in this context are not only related to recruitment fees or to underpayment of their wages, but they are also trapped into different kinds of abuses, be them physical violence, deceptive recruitment, people signing up a contract thinking that they are going to deliver a certain type of work in their destination country, and when they arrive in their destination country, they realize that their terms and employment conditions are totally different than what they had signed up. In some countries, these migrant workers see their passport confiscated, so they cannot move out of their country anymore, and they certainly have limited access to remedies and access to justice to sort of make their claim and get their rights respected. Let me say a last but important part of the information. We are also observing that end employers are not always aware of the abusive practices that take place prior to the workers reaching their company in the destination country. So what we're observing is an extremely complex phenomenon, a wide phenomenon that's affecting a growing number of people worldwide, and that's certainly generating a huge amount of profits that are made on the back of the workers, but also on the back of the well-behaved and responsible businesses, but also made on the back of member states that are countries because of all the tax evasions, because most of these profits do not lend themselves to tax being paid by those employers. So now comes the question of what is the International Labour Organization doing to combat these practices. First and foremost, we are promoting one specific international labor convention that's dealing with private employment agencies, which is Convention 181, that's regulating at the international level the placement by private employment agencies. At present, there are 28 countries that have ratified that convention. And we are, in the promotion of that convention, we are enjoying very close collaboration from the employers, so from the industry, the placement industry, that's really eager to promote the businesses that are behaving well, that are respecting laws and regulation, and there are many of them out there, and they really want to preserve that part of the industry that's respecting rules and regulation, and they are one of our key partners in promoting the ratification of the convention. And once a country has ratified the convention, obviously it will also implement it in its national regulation. We've also taken another initiative which we call the Fair Recruitment Initiative. There are leaflets that are explaining the initiatives spread all over the room. And through that initiatives, our first aim is to better understand the very complex setup through which business are recruiting foreign workers, better understanding who is migrating where and for doing what, how the business community organizing itself to making sure it's being done in full respect of the law. And we are also accompanying member states to put in place to address the regulatory gaps, because one of the thing we have been observing is that there are a huge, because this phenomenon is quite new, there are a number of regulatory gaps being internationally or nationally that need to be addressing. So in that initiatives, we are partnering with the business community and with the International Organization of Employers, and who is going to speak just after me. But also with the international trade union movement, and with a number of other organizations that are dealing and working on these issues. We are going to be testing and documenting good practices, and we are going also to publicize these good practices to make sure that fair recruitment being a critical moment in the migration of workers abroad, making sure that we promote fair recruitment practices, which is going to reduce drastically the problem of forced labor some migrant workers find themselves in. And as you mentioned, Irina, and I'll stop on that information, the last thing the International Labour Organization did was to supplement the old Forced Labor Convention, which dates back 1930s, by a new protocol that's mainly addressing the implementation gaps we found with this new phenomenon taking places. And so for 10 days, employers, workers, and member states discussed in Geneva. We finished the work last week And we've adopted a protocol with an accompanying recommendation with very clear provisions on how to prevent from forced labor and how to also protect workers that find themselves in a forced labor situation, and the protocol regulates also compensations and remedies that these that these people that are in forced labor can have access to. It was really an historic moment because the Convention 29 not only was an old convention, but it's a core convention. It's a human rights convention within the international labor law framework, and we've been able to modernize it to make it relevant to the challenges that I've been just describing. So the next step for us will be to promote the protocol, so to get a number of member states ratify the convention, and then we're going also to assist member states to implement it in their national law, national systems, and also revisit the remedies that are in place to make sure this phenomenon is really tackled properly. So that's what I wanted to say in terms of the global scene and the global sets of information. Thank you.
Спасибо большое, Карин.
Thank you very much, Corinne. As a matter of fact, I would like to share it with the audience that when I tried to contact Corinne to discuss some issues relating to the conduct of this roundtable in the past few weeks, she was practically inaccessible, which is an indirect confirmation of the hard work you have been doing at this protocol. And thank you very much for this first-hand information about the Fair Recruitment Initiative and the Forced Labor Protocol. Thank you very much. Now I'd like to turn to Roberto with this question. We've got some migration flows, people moving from one country to another, either at the request of companies or for other reasons, and workers move from country to country because some markets are short of certain skills that are in excess in other markets. So what do you think, Roberto? How do these migration flows correlate in this context with the skills gaps that exist in various countries? And another point, I know that you have taken part in the development of a European directive dedicated to secondment issues. It would be very interesting to hear from you your comments on how this directive is working, because this is also very important for us.
First of all, thank you very much for this invitation. It's great to be here in St. Petersburg. I assume that I have more or less 10 minutes to talk on these two issues. So please tell me if I am going beyond because I assume that others also will have to intervene and I will not to take the time of others. Also, please tell me if I'm going very quickly for the interpreters, because sometimes I know that that's an issue. Okay, I will try to do both, but to be on time with the two topics and at the same time to be as clear as I can for the interpreters and for you. Well, first of all, let me just very briefly tell what the IOE is, the International Employees Organizations. We are an old organization of almost 100 years. We were created in 1929. Our members are the business and employers organizations more representative of each country. We have 150 business and employers organizations that represent the majority of the business and employers community in 140 countries. There are three criteria to be members of the IOE. One is you have to be independent. You cannot be dependent on the government. Secondly, you have to defend the values that we defend, which are based on social issues, but also in market economy. And thirdly, also, you need to be the most representative. I mean, you have to be a representative organization. We are known because we are involved, legally speaking, in a formal way in the United Nations system. Especially, we are the ones coordinating the business voice within the ILO, the International Labour Organization. We are very active, but also in other agencies, especially in the United Nations, and with all the debate on business and human rights. That's what we are. Why we are very interested in participating in this discussion? Because we really need to interact with practitioners. We really need to interact with persons that are on the ground dealing on a daily basis with the specific legal issues which we have also to deal with at international level. For us, this kind of interaction is critical and is very useful. I would like to clarify that I will not get into all the technicalities of the issue that is going to be discussed here. Rather, even though I am a person with a deep and somehow nostalgic vocational legal background, my role here is another one, is to provide you a broad perspective which could help to open the debate from a more technical basis. And on the two areas. One is why the secondment figures, the secondment concept is important for business, is important for society, and is important for workers also. And I want to underline that from also a skill gap perspective. And secondly, and very briefly, what are the main challenges that we perceive in order to have proper institutional and legal framework for secondment. But perhaps, because we have been preparing this discussion, we have to clarify what secondments are, because we sometimes talk about different things. My understanding, and I want also to submit that to the critics of my colleagues, is that when we talk about secondment, we talk about a company that is providing a service to another company. Basically, this is the idea. I provide a service to another company, normally abroad, but it means that I have to attach my workers to this other company. This can be completely different companies, one here in Russia and another in Germany. This can be two companies that belong to the same group, but are different legally speaking. And also it can be a temporary agency acting here that provide a service to another company abroad. This last item, I mean the temporary agents that is providing a service to another with their workers, of course, is a delicate issue which has led to some illegal abuses which were referred by Corinne in his intervention. I have to say that we fully support the approach of the ILO on this. There is a convention of the ILO, which is Convention 181, which is one of the most favorite conventions for the employers, and I can assure you that we are not very fan of all the ILO conventions, and we are very critical sometimes with the ILO. I mean, but on this area, I had to clarify that we are fully supportive of the approach of the ILO for this abusive use of recruiting through illegal temporary agencies that are dealing with issues that are linked to trafficking, but that's another thing. Why is it important to have an institutional framework for secondment from a business perspective? I think that I do not need to explain to you how, and I emphasize how globalized the world is now. I don't think that it's necessary for me to deepen with you how critical and crucial the economic integration process have developed in the recent years all over the world. And consequently, I do not need to explain you with detail how interdependent we have become, not just from a business perspective, but also from a societal perspective. And how complex sometimes the relationship within companies are. It's essential sometimes for companies to be able to provide an immediate quality service to another company that is abroad. And in order to do that, sometimes it needs to rely on the workers that it has at this specific moment. Sometimes it's an immediate service, sometimes it's a very limited temporary service that it needs to provide to another company. In order to do that, it needs, of course, a proper legal and institutional framework, but also it needs a kind of proper cultural element, which I would refer after that. I have to say that these practices have been very common in the past, above all in some sectors, like the ICT sector, like the assembly sector, when companies want or need to provide a service of assembly from an infrastructural perspective to another company, in the maintenance services, but also in the consultancy service. It's very common that companies provide a specialized worker to another in order to coach them or to help them in making some strategical and organizational changes. But this perhaps could be considered the traditional trends in the secondment process. This tendency is growing. We have been just talking about the figure within the European Union. It's very low. It's 2% of workers could be considered as seconded by their own companies to another company. But I'm sure, and the data that we are now handling, not just at European level, but also at international level, is that this trend is growing, but also in other sectors that are not so traditional in secondment. It could be wrong to consider that that's just something good for business. It could be critically wrong. Because at the end of the day, this also benefits labor mobility, and this also benefits workers themselves. I mean, the experience, the competence that a worker acquires having worked in another country, being seconded by its own company, is really critical for its own future. And that's something that we have also to promote in a globalized world. And it also would be wrong to believe that that's something that will just benefit the workers of the company that has transferred them. At the end of the day, this secondment process are a kind of transferability of knowledge process, which benefit also the workers that are working with these workers. I mean, the idea and the link from a skill perspective that this figure is providing to many companies is that at the end of the day, their own local workers will learn from this competence that the secondment have provided to them. And this is highly beneficial on a reciprocity mood. I am telling these three critical elements of benefits, both for companies, for workers, and also for the economy as a whole, because there is sometimes a lot of reluctance from a cultural perspective at local and at an international level to promote these kind of figures. I have to say, and I have to underline, that at the end of the day, promoting the diversity of providers worldwide will benefit the competitiveness of the economy, because at the end of the day, you'll have more quality services, which will improve also the standard of living of the country. You do not have to underestimate that even in emerging, and both in emerging and in developed economies, the skill gaps is a challenge. I have just been handling some figures in Asian countries, which are now very fashionable in terms of investment. There you can find skilled workers, but at the end of the day, many of the employers investing in these countries find that it's sometimes difficult to find the specialized workers, not just with the technical competence, but also with the so-called soft skill competence, which have to do with the capacity of initiative, with the leadership, with the teamwork, the reliability, etc. Just to provide you a figure that has been published recently by the World Bank, 74% of employers in India, which is a high country in terms of investment, are just very low satisfied with the quality of the new hires from a local perspective because of this lack of soft knowledge, above all in some tertiary education levels. And in order to bridge this gap, the fact of counting of these secondment figures could be also very helpful. Those are the ideas that I would like to underline in terms of the importance of the issues that we are discussing. But I would like also to make you know what are the main challenges that we face here. The first one, from a cultural perspective, is the lack of culture favorable towards secondments. In many countries, it's not very well seen beyond the legal obstacles, beyond the also institutional obstacles, it's not very well seen the fact that a company sent foreign workers to work, whereas this company, the host company, could have recruited also local workers. And that's something that needs also action from a more political and policy level. But beyond that, and that's the issue that we have to discuss here, there are important and sometimes very inexplicable legal obstacles. The first one is, what is the regulation applicable to these workers? If we consider that this is a service that the company is providing to another company abroad, you could have two options. The first one is to consider that the regulation applicable is the regulation applicable of this company, of the headquarters of this company, of the company that is sending the worker. Normally, the criteria used at international level and also at national level is that you have to apply what is called in Latin the lex loci laboris, which means that is the regulation that is applicable in the place where the worker is providing its service as a worker. If we follow this rule, it would mean that at the end of the day, this worker, when it comes to Russia, by instance, or when it goes to another country, will be totally submitted by the local labor law. But there are some regimes, and I am talking now about the European regime and also in some Latin America countries because there is special treatment, there are special international conventions there that consider that at the end of the day you have to apply the lex loci laboris of the place of the work where the worker normally works. If this is the rule, if the place where the normally worker work is a country of origin, normally you need to apply the regulation of origin. And that's the general rule, and I'm talking in a very simplistic way that is applied in Europe. As it's a service, and as I as a worker normally work I give you an example, in Spain, I do not have, in theory, to apply the regulation of Germany if I'm seconded to Germany, because normally I'm working in Spain. Of course, that could lead to abuses, and there are some solutions for that. But I assume that in many countries, this is simply not possible. You have to totally apply the local regulation, which means, and I have learned just now, that in some countries you have to finish the employment contract that you have with this worker and to start a new employment contract with the host company, which at the end of the day means that the secondment is not possible. You have two different contracts. But in many other countries, because of this international treaty, you can apply this other regulation, which means that you apply the local employment contract, but in order to avoid abuses, there is also some solutions. And the solutions that have been found is that some aspects of the host regulation also need to be applied. What are the aspects of this host regulation that need to be applied? Normally, minimum wages, if they are applicable to all the workers or in a specific sector of in the country. Normally, you also have to apply working time regulations. Normally, you have to apply also the health and safety regulation and also non-discrimination regulation. But those are basically the provisions that, at least at European level, are foreseen in order to avoid abuses. To sum up, I can apply the local regulation, the Spanish regulation, but in order to avoid abuses, I have at least to fulfill these also host regulations that are applied to any other worker in this country. But again, there's also some difficulties to that, because some countries consider this as a minimum. In the case of Germany, by instance, just to give an example, it's not what is happening. They could say, well, these minimum requirements, like wages, working time, health and safety, for me, I consider them as a minimum, and I can require to to the seconded workers more requirements. I can also go beyond that. This has been forbidden, more or less, by the European regulation because it's against the freedom of services. And it has caused a lot of controversy at European level. At the same time, there are some more complexities because how we define temporary work, how did we define this temporary nature of these services? It is 2 years, 3 years, 4 years, 5 years, it's not still clear. What are the other challenges that we have also from a regulational perspective? Well, the other challenge that is critical is the coordination of the social security schemes. At the end of the day, if we are seconding a worker in another country, this worker needs not to be losing their benefits or the benefit that it could acquire as if he had been working in its country of origin. If I'm working in Spain for 5 years or 10 years, and then I came to Russia, the ideal situation would be that the waiting periods that I need to have access to a pension, I do not lose it because of coming here. At the European level, there are some very detailed regulations, and I am probably sure that you have many other regulations bilaterally of an international level. But this is not always the case. And even if it is the case, the problem that we have and we face is sometimes these regulations, first of all, are very complex, and there is a lack of coordination because of the specificity and very diverse social security systems. You have systems of social security in which the first pillar is the main pillar, and in other systems, the second pillar, which is the complementary pensions, is the major part. Coordinating that sometimes is crazy and creates some distortions that are very challenging for these secondment institutions. And the third main challenge, apart from what is the regulation applicable, what is the social security coordination effective system, is the migration regulation, of course. And this challenge is very critical. Sometimes the work permits takes a lot of time. Sometimes it's not just a question of time, it's a question of many, many bureaucratic requirements. Sometimes it's just the requirements not for the worker itself, but for its own family, which is critical, and we have been discussing that. And sometimes, again, is the lack of coordination internally within the labor authorities and the justice authorities in a specific country. All these areas are very, very challenging and need to be solved in a short-term basis. I could finish my brief intervention. I don't know if I have overcome the 10 minutes. That the key element to success on these figures is to be aware and to really understand that these secondment practices are drivers of bigger changes, are drivers of big impacts, not just within companies, but within society as generally speaking. And for me, that would be the main action that we should be tackling in the near future. Thank you very much.
Спасибо большое, Роберто.
Thank you very much, Roberto, for a very detailed presentation, even though, there are different schemes for the flow of workers between the various entities, but still what Roberto has mentioned, this remains very relevant for all countries, and that is the migration rules, work permits, work visas, and considering that we're all practicing lawyers here, our customers face these issues one way or another. It becomes easier in one place but more difficult in another. So I'd like to ask Ekaterina a question about what is FMS doing now? What issues are they tackling at present? And what do you expect to do in the near future? Maybe some additional changes in our legislation. What will happen with quotas? It would be nice if you could share your comments with us. Thank you, Irina. Thank you for the invitation to take part and for the opportunity to listen to our colleagues. I'm very grateful to Roberto for touching on the issues that require solutions. And out of those 230 million world migrants mentioned here today, almost 18 are related to the Russian Federation. Most of them are people coming to this country from the CIS countries. We have some 75% of such immigrants, and you know that the immigration regulation for visa-free is one, for visa-based immigrants is different. We have some 13% from the European Union, which is a fairly important number as well. But this is not just about different procedures for immigrating and working, and our relations, visa-based or visa-free, with the various countries. This is also about work regulation and permitting documentation for the work in Russia for people with different level of qualifications, skills, experience. And what would be interesting for transnationals was formulated for the first time when we prepared not even our internal regulations, but the international agreements to regulate workers with France, which was signed in 2005. I will discuss it in more detail because it found its reflection in our domestic legislation as well. This agreement now has this notion of highly skilled workers, and this same agreement now has the definition of people from one company, workers of one company, something that we don't have in our legislation. So that's where we made the attempt to provide benefits to those workers who are seconded by the French or Russian party to work for another legal entity, and they were provided with certain preferences, like obtaining a visa for a period of up to 6 months. And if the secondee comes under the national jurisdiction, then the secondee obtains the right for a longer period of work. Now, in preparing this agreement, we worked very closely with business representatives, and that's when the issues were formulated that were and continue to be outstanding. This annual cycle that the employer has to go through every year to obtain the quota, work permits, and work visas. That's number one. And number two is about the ratio, the proportion of the various jurisdictions, the jurisdiction of the country of origin of the worker and the jurisdiction of the country where the worker is working. Now, most companies that second their workers to Russia are interested, and the workers themselves are interested in keeping the fringe benefits, and second, taxes to be paid in the country of origin. Our legislation today stipulates that the agreement must be, the labor contract must be made with the Russian legal entity, and based on that, all other permitting documentation is issued. Now, what companies usually do to keep the fringe social benefits of the country of origin and keep payments of taxes. And that is a civil contract, civil law contract, according to which many workers that come on a visa-based procedure, they come here and spend years and decades in the country with their visas. This is not a totally correct situation in terms of temporary residence in a country or temporary accommodation. So we are now working on amendments to change this temporary residence and for these permits to be issued depending on the purpose of the entry to the country for people who stay here for longer than 90 days. And of course, work will be a different topic that requires regulation, including as regards insurance and pensions, because temporary residents are entitled to some social benefits. Now, this treaty with France was a first such document. Then the high-skilled specialist notion appeared in our legislation, and those workers are different from the rest, not just because they have a package of preferences, but also the compensation level, which should be no less than 2 million rubles per year. And this criterion is the only objective component. Anything else is in the competence of the employer. These workers have the right to work permits, work visas for them and their family members, beneficial tax rate or a income tax rate, same as for Russians, 13%. There's more than 60,000 work permits issued today, and the most relevant today is to prevent abuses, because this institute is fairly attractive in terms of the benefits that the workers get, as well as the employer, because the employer is not engaged in the quota campaign. And there is some legislative initiative underway right now, which is about the performance by the employer of their obligations to pay salaries and wages, and they submit salary and wage payment reports not on an annually but on a monthly basis, so that this becomes clearer and more transparent. Then I'd like to note the law prepared by the Ministry of Labor after Russia's accession to the WTO. We were supposed to meet the requirements of preferences for key personnel, and this contains elements that are characteristic of global companies, like simplified employment procedures for subsidiaries, affiliates, and rep offices of foreign companies. But at the same time, the worker's obligation is still there to have a employment contract under the Russian legislation, to be made in Russian, and to stipulate all the obligations of the employer to the employee. Another point regarding the simplification of these procedures for the transnationals, and this is the opportunity for rep offices to attract highly skilled workers. It was limited initially in the law, but now, based on the initiative of the Chamber of Commerce and Industry, amendments were made in the legislation related to the accreditation of subsidiaries and rep offices. So now they have received this preference.
Another interesting law, also drafted by the Ministry of Labor, spent a lot of time at the State Duma with MP Isayev working on it, had to do with a ban on borrowed labor. But although borrowed labor is prohibited, it provides for quite a number of provisions for the transfer of a worker from a private employment agency to a legal entity. And the employment agency should perform the function of a full-scale employer, whereas the worker enters into an additional agreement with every end employer, regulating their work conditions there. This law will come into effect in 2016, and it has now triggered a debate, because it is not only that a private employment agency will be entitled to offer workers or as a service to other companies, but also legal entities affiliated with other legal entities, and that procedure is to be regulated by another federal law. And this raises a lot of issues before us and before business, because we need to define the concept of affiliation between legal entities. And one should be clearly aware of how guarantees are going to be defined along with the employer's obligations, how this is going to be applied to Russia, to what extent Russian law and foreign law will be applicable to those relationships. Another open question is how foreign workers or employees are going to work as part of personnel hire, and this will have also to be provided for in the migration laws. So the Federal Migration Service is going to elaborate those provisions, and I hope that both foreign companies operating in Russia and Russian companies involved will take part in those drafting activities. And we need the practices that there are already in actual life will have to be embodied in the legislation. As regards visa-free labor migration, well, the President's message to the Federal Assembly this year set the task of establishing order in this labor migration or migrant worker movement practices, and the introduction of patents whose value will be determined by constituent members of the Federation. Now this bill is already in the Duma and will and is to be considered either in late July or early August. It discards job quotas, and the idea is that the number of migrants will be regulated by the price of the job patent. That's a revolutionary bill. All regulations existing today will be changed by that law, but as any revolutionary thing, it has caused a lot of debate. Well, I have outlined it the way it is now, but it may take a different shape when it goes through Parliament. Thank you very much. You have actually touched on some very interesting subjects, and the issue of patents is very interesting, and we would like to see how this idea is going to develop and how what it will look like in the first reading. As a matter of fact, I was going to say that all the lawyers present here will speak on the issue of the lease of personnel and secondment, and maybe some of that experience will be of interest, especially in the context of the work underway on the law on secondment, but also in the context of what has to be additionally developed. And I would like to ask Denise to tell us what you are confronted with when you have to deal with the movement of people within one company or between a company and its affiliated entities inside or outside Russia, and what are the most frequent issues you have to deal with? Thank you, Irina. Well, these are I'll concentrate on the practical issues that we are faced with as in-house lawyers. We are unlikely to face issues that Corinne and Roberto have spoken about. Our task is to use law in the most effective and efficient way, and to save on time and administrative costs for the worker and for the employer. We are not faced with the issue of unwillingness to comply with the law. We are just selecting those provisions of the law that would provide the best and most efficient relationship between the worker and the employer. We are also restricted by the areas where we operate. This is there's one of them is mobility or relocation of personnel among companies of the group, and I mean here companies that find themselves in different jurisdictions or countries. And another issue is the employment of foreign workers when foreign citizens come to Russia to work here. So I will speak on these two issues and what problems arise. They arise when acquired foreign assets are integrated, and our company has vast experiences as a result of acquiring a Serbian oil company. We also purchase, we can also take part in other entities without taking control of them, or when we implement new projects in subsidiaries, when the subsidiaries themselves don't have the competences. And another area where this is necessary is the replacement of temporary vacancies, which are of importance, and of course the specific issues that we have to deal with, like when we need to upgrade, when we exchange employees to upgrade their skills, or the skills of those who will work together with those employees. We also need to fill vacancies that we cannot fill locally because of the absence of the necessary competencies in the local market. And another task is providing the necessary motivation for administrative personnel to upgrade their skills, and that is what international relocation contributes to. So we need to fill vacancies and competencies that are missing, and to assure the necessary level of risk management where the company is present. Now, considering that the issues that you have raised, I will now focus on the hiring of foreigners to work in Russia. And I will concentrate on how we protect the interests of foreign employees coming here. Of course, the people we are talking about are highly skilled specialists, especially as part of competence exchange programs. Now, the basic guarantee for any worker is that of salary, and we need him or her to have a clear understanding of what their work conditions will be and what their net salary will be after taxes, because the tax systems of different countries are totally different, and there are different conditions that have an impact on the net income. And the Russian law does not allow us to state the net income in a labor contract, in an employment contract. We don't have the legal levers for that, and here we would probably support amendments to the law which would allow that. And again, also in the administration of work permits, there are quotas, and there are certain dependencies on the members of the Russian Federation. When a company has a number of subsidiaries and daughter companies where competencies must be filled in several legal entities, this is an added complexity. Of course, it's all solvable, but it requires some additional effort. And here I would also discuss the sending of people who work on contract with the Russian companies to a foreign company. Now we have considered the opportunities and that the Russian law offers, including the advantages and disadvantages of various legal mechanisms. One is the first thing that comes to one's mind is secondment or sending one on a business trip. If we send someone on a business trip, then we don't need the workers or employees' consent, but all the guarantees that they have at their primary job have to be secured. So no issues associated with the duality of jurisdictions arise here, but what we are faced with here is quite a number of shortcomings that prevent us from using this method. The status itself. A business trip presupposes the performance of instructions by the primary employer, not the administrative executives at the place of the trip. And then it has to be limited, it has to be temporary, and it has to relate to the basic work functions. The next issue is has to do with financial guarantees. The period of secondment is not included in the calculation of the average salary and under Russian law, and that is a disadvantage if the period is long enough. Then there are tax issues. If a person remains in another country for a period of over 183 days, then tax issues arise both in Russia and in the country of destination. And then the employer also is faced with tax issues because such a trip or secondment has to be directly related to the main functions, to the employee's main functions. It's not a very strong risk, but it does exist. And other methods that we have analyzed is combining jobs. When you perform your functions at two places of work, and the main advantage is that an employee keeps his or her primary job and everything associated with it, all the guarantees and everything. This is of great concern to all those who go abroad, and this is what they want to retain. Any job combination, well, it requires that we get the person's consent every time. Then again, the time of the work hours have to be limited, and so the most frequent legal mechanism for relocation is the dismissal of the employee at the primary job, and then the hire of that person at the place of destination if it's over 6 months or, for example, a year. So that's the basic mechanism, dismissal plus employment. But there we are faced with issues in assuring the guarantees and keeping the protection factors, and some workers are afraid to go. They don't always go to Europe or other countries with well-developed labor law, labor guarantees and compensations. These issues is something, I mean, they don't always go to those countries. They sometimes have to go to countries where these rights are not guaranteed, and the need arises for those rights to be guaranteed. And then tax leveling is causing more issues. It is well known that the income tax rate in Russia is one of the lowest in the world and one of the most attractive. So relocation to another country entails the payment of a higher income tax, but in Russia we are not allowed to state the net salary or net income in the contract. Of course, there's also the practice of special purpose vehicles when companies, either national companies or companies having assets in several countries, set up special purpose vehicles which come out as the employer of all the staff, and that enables them to select the most efficient jurisdiction. But then again, we have to come back to the issue of the ban on leased labor and in Russia, and we do need further discussion of that. Thank you, Denise. You have stated a set of issues that inevitably arise both for a transnational company and an employee who are interested in keeping all the benefits, guarantees, and compensations they have previously. So this is a reciprocal set of issues, and we would like to discuss that in the light of the law banning leased labor in this country, which comes into effect starting from January 2016. So temporary relocation is allowed under a federal law which has yet to be developed. Now, we tell European country. Well, we know that there are European countries where leased labor is also banned, but there's secondment, which is well regulated and works well. So we would like to hear how these issues are indeed regulated. Is there any time allowed for discussion and questions? Let's check our time limits. We have only 35 minutes left. All right, maybe if you are tired of hearing presentations. We're not tired, but I am interested to know whether we... Let me introduce myself. I've come from Estonia, I am an operating lawyer dealing with migration issues, and all the issues you are discussing here, I am listening attentively and trying to apply to the model we've had for 20 years. So I just want to know if we are going to have time for a discussion. We do have some 10 minutes at the end for questions and answers. And of course, this is what we are here for, so let us try to be brief in mentioning the experiences of all countries, of various countries, so that you could take part in a discussion. But as an introduction, I would like to ask Stefan Fischer to tell us how issues of leased labor and secondment work in Germany from the perspective of relocation within one group of companies, or when some Russian employee is temporarily moved to Germany.
Irina, first of all, actually my original intention was to congratulate the Russian team this morning to their great victory in the football World Championship yesterday, but obviously that is not a good start. So I will immediately go on to answer your question, Irina. Sorry, questions on that. All right. Secondment and lease of personnel. Well, lease of personnel is something that is not prohibited in Germany. Actually, we do have a law since 1972 that allows employers and even agencies to lease out employees to different employers. There is a number of regulations that apply to that. You need to have a permit, something like that, in order to be able to lease out employees, but at the end of the day, that is allowed. The effect of leasing out employees actually is that the employer that gets the employee is acting as if he was the employer, although the other one is still formal, the employer paying the salary and all of these things, but the employer who gets the employee can now give directives to that person, and that is applying also in transnational situations. So it would even be allowed for a foreign employer to lease out employees into Germany, and vice versa. German employers could lease out their staff to foreign employers. For intra-group situations and scenarios, there is an exemption in the German law, meaning within a group, the restrictive regulations will not apply. So within a group of companies, it is possible, let's take the example of Denis, within the Gazprom Neft group of companies, it would be allowed within Germany to lease out an employee from one company, from one legal entity to another. Secondment, on the other hand, is a different concept and has a different purpose. Very often, the lease of employees is even something that is done for economic reasons. We have agencies that that hire people just for the purpose of lending them, of leasing them out to different employers. Actually, when we're, get a little bit political, the past 10 years, we have obviously seen a vast economic crisis, not just within Western Europe, but throughout the world, of course. As for Germany, we can say that our extensive liberalization of the leasing of employees has been has had a major positive impact on our job market situation. Secondments, maybe it's just in order so that I'm speaking all the time myself. Maybe Sophie, you can help me about the concept of secondments.
Yes, good morning or good afternoon. For us, it's still morning, so that is why I'm still a bit confused. For us, the concept, I'm from Belgium, but I think I can speak here for Europe, the concept of a secondment is that an employee remains employed by the home country, who then temporarily sends out the employee to another country. I understood from the discussion that we had before that in Russia that is not possible. That, for example, and the other way around, if I would be a Belgian company just sending my employee, my Belgian employee, to Russia to work here temporarily, let's say for 2 years in a Russian company, that is not possible because he needs to have a local employment contract with a Russian company. In Europe, that is possible. It is possible to remain employed by the foreign company and to temporarily work here. But there are some limitations on it. And the first limitation is always watch out for temporary lease of personnel. It is to some extent allowed, but it comes, as Stefan was saying, it comes with some conditions. It's not like we can do whatever we want. For example, in my country, in Belgium, it is allowed for intra-group secondments within the same company, but it needs to be formalized. There needs to be an agreement between the 3 parties, between the 2 companies and the employee. It needs to be temporarily, and the employee needs to be granted, in case of an intra-group secondment, the same employment conditions as the local employees. Another way to get around it, I would call it to get around, because formally it is not a lease of personnel, but that is the way we structure it, is to do it as a subcontracting arrangement where one company gives a service to another company, and that service is being provided by the employee of the first company. Again, it is subject to some conditions, because it must be formalized, must be a written agreement, and so forth and so forth. So I hope this answers
Да,
your
спасибо,
question.
София. А как это работает в Италии, Марко?
How does it work in Italy, Marco?
Russian phrase because my ear translator was not in its place, but I guess it was about the Italian situation.
Exactly.
All right.
No, it was about Italy playing football.
Okay, but that's good news up to now. So thank you. Well, the framework, the legal framework is much the same about what you heard about Germany and Belgium. So lease of personnel is permitted in Italy subject to conditions, and especially subject to public authorization. So not everybody can lease personnel. What is prohibited is the lease of workforce. So just being an intermediate party between a work and a provider of work, where you have no economic interest in the operation and you just sell hours of work, you just sell workforce. That is prohibited, and has both criminal and administrative sanction if a situation, regardless of the way it's formally structured, is found to be illegitimate lease of personnel. So lease of personnel permitted under conditions. Secondment is permitted. The framework is European, comes from a European directive. Secondment is one of the simplest contractual structures and one of the most problematic, as it always happens, because the concept is very straightforward. You have to keep the link with your employer, let's say back home. There's no secondment if there's no organic link with the employer back home. So it's not just a payslip. Well, it is the payslip. Without the payslip, we're done from step 1. But it's not just the payslip, is the actual power to manage the employment relationship. So disciplinary power, organizational power, everything goes back to the company back home who sends the employee in secondment. What happens with secondment? Under Italian law, we've had a definition since 2003, and beforehand it was just court cases and the directive. So it's relatively young as a formal figure in Italian employment law. What happens with secondment is there is a two-way street for the relationship. The employment relationship and the actual performance of the service. The other necessary element for that is the mother company, the employer, must have an interest in the secondment, and this interest must be there all the way. So I can't just say, go there, and I'm not just talking about intergroup secondment. You can have secondment towards third parties, you can have secondment towards association, but the interest must always come back to the employer. So it's not a service provided, it's a service that comes from an interest of the company. And that is the link between the employer and the third party. So, employer, third party, and employee. The employee stays with the employer, is managed with the employer, but performs an activity that is formally inserted in a contract or a letter at the secondee company. I leave you with an example that renders, I think, the complexity of secondment. That is a very straightforward law concept. If an employee does a malpractice or does something wrong while he's on secondment, in order to discipline him, the company where he's staying needs to call the employer back home and say, listen, your employer, Marco, for example, let's pick a name, did something horribly wrong. And the disciplinary letter, according to Russian law or Italian law, depending, starts from that company and is signed by that company, but arrives at the other. And the whole procedure is carried out with the mother company. So that's more or less the legal framework.
Да, спасибо, Марко.
Yes, thank you, Marco. But you mentioned the situation where the worker did something wrong. But how about social responsibility for the employee? How is it distributed in the case when the employer is in one country, the host company is in another country? What's the status of the worker in terms of social guarantees? How is this regulated? Can I ask this question to Sophie?
If I understand you correctly, by social guarantees, you mean social security rights?
Social security rights, right to work, right to be compensated to a certain extent.
Yeah. Because that are two things we need to make a difference in. So first of all, we have the social security rights. It's what you build up to be covered, your pension, if you're sick, the fact of being reimbursed, your sickness insurance, and so forth. If it is a secondment within Europe, and I emphasize from one European country to another European country, it is regulated by a European regulation which states that if an employee temporarily works in another country, he can remain subject to his own social security. So he continues to build up social security rights in his home state. He does not become subject, and the employer does not have to pay social security in the host state. That's something specific in Europe, but it's limited in time. According to the regulation, it's 2 years, but for most countries, it can be extended up to 5 years. So basically what it means, for example, if I have an employee who is employed, let's say Stefan, your associate, comes to work in my firm for, let's say it's 3 years, then she can remain employed under her German employment contract, and the German company continues to pay German social security and is exempt to pay social security in Belgium. That is within Europe. If it is from outside Europe, we need to look, or from outside Belgium at least, outside Europe, we need to look if there is a treaty between Belgium and that other country. And that, if there is a treaty, a social security treaty, the principles are the same. For example, we have that with US. There are US employees coming to work to Belgium for a maximum period of 5 years. They don't pay social security in Belgium. They continue to pay in the US. We do not have that with Russia. So that's not possible with Russia. Most of the time, if a Russian employee would come to work in Belgium, there's a high chance that he will need to pay Social Security in Belgium as well. So that are the Social Security rights. From the employment rights, let's say the minimum wages and so forth, that is also a European regulation. There is a core minimum where you talked about, Roberto. If you come to Belgium, even if your contract remains in Russia, there are some core minimum rights that you always need to apply, even if the employment contract is not subject to Belgian law. And that is the right to have the minimum wages of Belgium and so forth and so forth. But that's based on European legislation, but what is very important is that the principles are in Europe everywhere the same, but the local implementation in the details is always different. So you always have to check country per country.
Спасибо, София. А вот тут, кстати...
Thank you, Sophie. There's an interesting topic here. What if, in the course of this temporary movement, I'm sorry, that question is going off the microphone. Right, I heard. Where should the employee go in the event of a dispute? That is, the employee is seconded to Germany. I understand you have some very active judicial practice there. And suppose the worker is working in a German company and is not unsatisfied with the quality of the workplace or something else. What if he's unsatisfied? Who is he supposed to go to have his rights protected? Where is he supposed to address his dispute?
What are we talking about? Are we talking about seconded employees or are we talking about leased employees? If it's a leased employee, sorry, my Russian is not sufficient.
Leased. We're talking about leased.
Not.
Well, questions were off the microphone.
Yes.
В их понимании это временно перемещение.
Okay, seconded is temporary moved on a local Russian contract, where leased has nothing to do with Russia, essentially.
Я прошу прощения, что все вопросы ушли в пустоту.
I'm sorry, my questions went into thin air. Okay, all questions were about compensation, but labor relations are not only about compensation, but about work conditions. Now, take European legislation or a Russian employee, doesn't matter. He comes to a different country, he's got compensated, that's okay, but then health and safety, because there's no question when he's at home. He will go to court. What if he's in a different country? He's not an employee of that German company. He's an employee of a Russian or Belgian company. Where will the dispute be considered? Because in a static situation, there's no problem. The problem is when there's a conflict. So which court will have the jurisdiction? A German court? Or and what legislation? German legislation, Belgian, Russian? How will that be tackled in the event of a conflict other than about compensation?
I have understood. Otherwise, please correct me. So we are talking about a person that has been leased out, let's say, to a German company. It's a Russian national. He is employed with a Russian company. I understand it's a little bit difficult with leasing out, but let's just take it as an example. Maybe he comes from some other country, but he's working in Germany. He's working? Yeah. So he's working in Germany. If we are talking about working conditions, let's say health and safety issues, that would clearly be an obligation of the local employer. And if health and safety regulations are not obeyed, the employee would be able to go to German authorities and get remedy from there.
Again, it's going off the mic. I'm sorry.
Вы имеете в виду, в какой суд?
You mean what court
sentence, and then we get it clearer. If it is something that is not, concerning working conditions like health and safety things, but payment issues. If we're talking about payment issues or things like that, then he will be obliged to sue his formal employer, which in that case would be a foreign company back in his home country.
No, not in Belgium. If it is for example, in Belgium, if it belongs to the core and the minimum wages and stuff like that, then the Belgian courts recognize themselves that they have jurisdiction to that employee could sue the Russian company in Belgium for not complying with the minimum conditions. So the fact that there is no local employer does not mean that the employee who is Russian, he can sue his Russian employer in Belgium for not respecting the minimum conditions that apply according to Belgian law based on that European legislation.
Но фактически не соблюдает эти условия.
But actually, it's not the Russian employer who's in breach, but who's wrongful here. Is the Belgian employer, right? As an example, where he's seconded. So the Russian company has nothing to do there because the Russian company seconded the person, and it's the Belgian company who failed to comply.
Not if it's a lease of personnel.
Тогда работник просто вещь.
Then he's not a worker, he's just a thing.
Elaborate a little bit on this. There is some legal liability of the two employers on some specific areas, like health and safety, which means that I also have a responsibility, even if I have not an employment contract with the worker, but in terms of health and safety, I have also my liability. And I can address both. But also we have to distinguish between what we call, I don't know how to translate it to English, the forum, where I present the claim, which is what you were referring. I can present the claim in Belgium.
Place of jurisdiction.
The place of jurisdiction, and to whom I could address, because that's another.
Thank you very much, Roberto. From this perspective, let me get back to what we as English speakers understand to mean lease and secondment. Let me ask Julia, since Julia has been working on legal initiatives in this area for some years now, including as part of interactions with the European business community. So maybe Julia will help us to understand the terminology, especially as she is starting to work on a new draft law on secondment. Good afternoon, dear colleagues. Let me try and clarify the terminology a little bit, because we have discussed it with our European colleagues, like when we say secondment, lease, and things like that. So, in terms of the Russian, the European practice, the concepts are very close, like lease of personnel and secondment. These two terms are very close. The only difference between the two is that different countries have a little slight difference in the interpretation. Like some countries understand secondment to mean that this is only intercompany secondment or intergroup secondment. So agency workers will not be secondees. Other countries have a different understanding, and they say that secondment will include agency personnel provided by agencies as well. So that's where there can be a slight difference. Now, what happens in Russia? For more than 15 years, these techniques for the use of personnel using these methods have been in place and have worked successfully despite the fact that there's no legal regulation. Now there's the need for legal regulation. What will happen now? Up until 2016, the law does not recognize directly this mechanism of either secondment nor lease of personnel. It's not regulated at all, and this will continue until 2016. These mechanisms are not prohibited. They will continue to exist. You can continue doing what you do right now, but there's a greater risk in the recognition of direct labor relations between the host party and the worker. This risk used to be more remote in the past, but now, as we have these amendments in the labor code, this norm is now becoming stricter, and this risk becomes greater. Now, starting 2016, the situation will be as follows. We will have the concept of leased labor, which is prohibited, and this is in the interest, control of physical legal entity who is not an employer of this employee. So leased labor, this is the way it's going to be understood, and it'll be prohibited. As you can see, the terminology is so different and so unclear and so poorly defined that this gives room to a lot of abuses. However, starting from 2016, we will have a permission to provide personnel in a way where it is the agency who provides the personnel of the accredited agencies and under specific conditions. So this category of agency personnel, this layer, this cluster will be allowed. However, let me note that even though a lot has been said that you can use agencies to hire personnel, unfortunately, instances where you can use workers through agencies, it's only for very narrow fields, narrow areas, and I can even say that it will be virtually unrealistic to use this path. But let's see how it's going to work. So agencies are allowed, but only in specific cases. And then Law 116, adopted recently, also contemplates seconding workers from one employer to another if these companies are affiliated, or in the second case, these companies are parties to an agency contract or agency agreement. So in these two cases, the secondment of personnel will not represent leased labor and will not be prohibited. But it's also important to know that all the conditions and all the features of these methods are supposed to be set forth in a separate law that will describe all the rules and probably a lot of restrictions for companies. I am member of the European Business Association working group, and we're now working on this new draft law. Hopefully we will be able to describe this correctly, and hope to see an understanding both on the part of the trade unions and the relative ministries. We're working very closely together and discussing all the details of this draft law with the Ministry of Labor, the Ministry of Economic Development, and a number of other organizations. So we hope very much that we'll be able, in the remaining 18 months, to come to a consensus. However, unfortunately, the resistance is significant, and the fact that this is about quite a number of issues, this arises heated debate, and whether international companies, transnationals, and major Russian companies, whether they'll be able to use these mechanisms is unclear as of yet. But up until 2016, you can continue using the mechanisms as they exist today. Let's see what happens later. Nothing is clear in this respect, unfortunately. This is about terminology in a couple of words. Thank you very much, Julia. What you're doing is very important. Yes, definitely. I promised to give you some time. And of course, now we'd like to move to Q&A or comments. If you have anything to say, please introduce yourselves, raise your hand, and you will be given the microphone. Let me introduce myself. I am Tatiana Kim, practicing lawyer, entrepreneur, director or manager, as you like it. So regarding this immigration legislation, I'd like to say that all the labor issues discussed here today are regulated by the immigration legislation as regards foreigners. And this is more of a matter of politics. Whether the worker will work here or not, if it's going to be a foreigner, all foreigners are supposed to have work permits. Now, seconded workers are subordinated to the sending employer. If that's a foreign citizen who wants to work, regardless of whether he was seconded by a corporation or a subsidiary, these workers need to have a work permit. Last year, a significant condition was introduced. I'm not sure if that was for the purpose of protecting the worker or the state, where every foreigner has to be paid at least not less than 1,200 euros. That's the minimum for foreigners. If you're unable to pay such a salary, then you cannot receive any secondees. But it's still the immigration legislation that's important here, not the labor legislation. You had a question. Yes, but I don't really have any questions left because I was listening very attentive, listening to Roberto, Marco. I think European legislation is very close, and of course each national country introduces restrictions, limits where to let in and where not to let in. Thank you very much for your comment. I can see there's one more question over there. Thank you. Good afternoon, dear participants. I am Oksenia from Inmar Law Firm. I have a question to Ekaterina. I came from the Far East, and among Far East lawyers, there's this issue discussed about the draft law on social and economically advanced territories. In particular, there's one article that says that using foreign workers will be based on the relevant law, except for cases where there's no issuance of work permits for foreigners. Then invitation and work permits will not be issued for 1 year, and then this quota for the salaries for highly skilled specialists. So my question is, don't you believe that this gives a lot of room for abuses, because control on the part of the FMS will be restricted? Or is this made on purpose because these territories need to be developed faster than, in an advanced way? Thank you.
Заработной платы применительно к высококвалифицированным специалистам.
highly skilled workers, if they don't have this criteria used, then the idea is discredited. This can be justified for cases like Skolkovo. This is a um, isolated case, but for the Far East, this will not be the right thing to do. Pavel Gromov, FS Company. I have a question to Julia. In light of this law on rented leased personnel, there's limits to its application. You can use only affiliated companies or agencies or things like that. How do you see the prospects for the use of this, and how will the application of law work in this law? What will prevail in terms of use, or companies will just move to services contracts and this law will not be used in practice?
I believe that there will be no all-out transition to civil law contracts or services contracts by companies. I think the law is going to work initially for a very narrow range of cases, and I lay my hopes on the fact that gradually the law is going to be amended in a way that will expand its coverage and sphere of application. And we are working on a bill on personnel regulation, trying to adjust the shortcomings and compensate for the shortcomings of that law. And so my hopes are that it is going to work, and it, although initially, of course, I believe there will be an excessively broad interpretation of its provisions, but nothing happens overnight, and step by step I think we can hope for more or less normal regulation of employment and personnel, also within company groups. When companies are not affiliated, this is going to be prohibited, and for those cases I think alternative methods will be used by companies, such as the delivery of some kind of services, which is what is being applied today too. So do you think that the traditional areas such as cleaning or logistical or warehouse services that are outsourced today are under a high risk, and companies need to work with counterparts that are covered by the new law? What you mentioned are services in fact, and they are to be regulated by services contracts. As regards the lease of personnel, it takes place when a company does not accept a service but an employee, and they instruct that employee and tell them what to do. And what you mentioned, like cleaning and painting, are different things, and these legal relations have nothing to do with the law under discussion today. Of course, the distinction is very subtle, but it does exist. Whether it's the substance is a service, or the use of an employee or a worker at the discretion of the new recipient. Well, you were going to ask questions, but if there are no more questions, of course, we all have the right to take some to take a break. And if you do have questions, you can socialize during the break. Good afternoon to you.